Hello, everyone, and welcome. I am really thrilled today to be joined by Anu Bradford, who is a law professor at Columbia Law School. She has focused on uh, the law of, sort of broadly, international data transfer and technology development and competition, and has written a number of things very relevant to data privacy. Her latest book is really a tour de force. It's called Digital Empires: The Global Battle to Regulate Technology. I've read this book. It is really a absolutely terrific read. It's fascinating, filled with just tremendous number of facts and details about what is going on in the world. And it really provides this incredible overview and insight into the different approaches to regulating technology around the world and the battle between them. And we're seeing this unfold right in our times, and it's increasing in its importance. And the understanding that Professor Bradford has given us in this book is really indispensable. It has really deepened and enriched my understanding of privacy around the world and what's happening and what these companies are doing in light of these tensions that we're seeing between these different regimes in the world. So thank you for writing this great book, and I really urge everybody to go out and get this book. It's terrific reading. So with that, I'd love to chat and talk a little bit about some of the ideas in your book, and in particular, at the center of the book are three regimes with very different philosophies on how to regulate technology as well as privacy and the digital world. So can you tell us a little bit about each of the regimes and their philosophies?
Great. So first of all, thank you then so much for having me. I'm really excited to have this conversation with you. So the premise of the book is that there is increasingly globally a consensus that digital economy needs to be regulated. But there is no consensus what that regulation ought to look like. So in the book, I indeed argue that there are three primary ways to think about regulation of technology. There is the American market-driven model, the Chinese state-driven model, and the European, what I call a rights-driven model. So the American market-driven model is really prioritizing free internet, free market, and incentives to innovate. So it is reserving a minimalist role for the government and in practice hands over the governance of technology to the tech companies themselves. So it is a techno-libertarian, techno-optimist view of the world, which generally manifests itself as a form of self-regulation by tech companies. So China is somewhat different. The Chinese government is very focused on making China a technological superpower. And under its state-driven regulatory model, it is willing to leverage state resources to meet that goal. But the Chinese government is also deploying technology as a tool for surveillance and censorship and propaganda in an effort to ensure social stability within the nation and thereby entrench the power of the Communist Party. So the Europeans are here often portrayed as being forced to choose between China and the United States and their respective digital spheres. But in the book, I argue that the Europeans are not prepared to, nor are they forced to choose between China or the US. So the Chinese model for the Europeans is simply too oppressive, whereas the American model is too permissive. So the Europeans have carved out their own, what I call a human-centric digital transformation and the regulatory architecture that supports exactly that kind of transformation. So it is emphasizing the importance of protecting the fundamental right of internet users and digital citizens. It is also very much focusing on the preservation of democratic structures of the society. But it also encapsulates this notion of fairness, a more fair notion of digital transformation, whereby we are transferring power away from tech giants to smaller companies, to individual users of technology, and to the society at large. So then those are in brief, the three regulatory models that I use analytically to structure the digital world in the making.
So we have these different regimes, and they're very, very radically different philosophies. And I'm wondering, you talk a lot about how they come into conflict, how they're not just interested in staying isolated to each region, but the U.S. wants the world to adopt its vision, the EU likewise, and China likewise. So how are each trying to exert their influence on the global stage?
Yeah, so that is really interesting, and it's the logic behind calling these empires, so digital empires. It is a provocative word, it's a big word, but I think it is also helpful for us to understand what's going on, because none of these regulatory models are confined to the jurisdictions themselves. Instead, each technology and regulatory power is actively exporting their respective regulatory models, and in that process, expanding their relative spheres of influence. So, but interestingly, they're all exporting something different. So the US is primarily exporting the private power of the US tech companies. They were set free to basically take over the world, and so have they done. So you have these US tech companies providing products and services to users around the world. So if you take just as an example of Meta's Facebook, it has 3 billion users in 160 countries. And through this presence of these companies in shaping our digital lives, they are also exporting this Californian ideology, this techno-libertarian foundation that is shaping in how those companies conduct their business. So China is exporting primarily what I call infrastructure power. They are building 5G networks, undersea cables, data centers, smart cities, safe cities, along this digital Silk Road that reaches across many parts of Asia, Africa, Latin America, and even Europe. So what are the Europeans then exporting? They are exporting their superpower, which is regulation. And this ties to my earlier work on the Brussels effect. So the EU is one of the largest and wealthiest consumer markets in the world. And there are very few companies that can afford not to trade in the EU. So as the price for accessing the European market, these companies are following the European regulations, including the GDPR, the General Data Protection Regulation. But often they find that it is in their interest to extend that European regulation across their global production or global conduct, because they want to avoid the cost of complying with multiple different regulatory regimes. That's why most of the today's big technology giants have adopted GDPR as their global privacy policy. So through this logic behind the Brussels effect, the European regulations find their way to shape the global marketplace. And this is how the European digital empire also expands its own sphere of influence. So what you end up having in many third markets or non-aligned markets, you have these empires coexisting or clashing. So at the same time, you have Chinese infrastructure, American tech companies, and European regulations present at the same time.
And so, who is winning? And in your book, you talk a lot about some of the strengths and weaknesses of each, the push and pull. And in particular, you note that the U.S. kind of had an early advantage, but that's waning now. And I'm wondering why. What is going on with the U.S. approach, and what are some of the forces that are leading to its being weaker now than before?
Yeah, so you're absolutely right that in many ways, the early stage of the internet revolution was really the influence that was growing, that was the influence of the American market-driven model. And that really provided the foundation for the digital economy as we know it. But in many ways, the US overplayed its hand. These tech companies became too powerful, and they started to exert the kind of economic power, political power, informational power, cultural power across the societies to the extent that individuals and governments around the world became increasingly uncomfortable with. So not only were these tech companies associated with many innovations that we love and have become to depend on, but also many of the harms that individuals and societies were experiencing were increasingly attributed to these tech companies. So we noticed that instead of really providing platforms for inclusive conversations that would make our democracy more robust, they were undermining that democracy with massive disinformation while also leaving us surrounded by information such as hate speech. The failure to protect the privacy of individual users also cause resentment across the world. And revelations like Edward Snowden's revelations of how the US tech companies were passing on our personal data to the National Security Agency, that becoming part of the US surveillance empire, also unsettled Europeans and other citizens around the world. And that created a backlash. So that then caused the regulators to assert themselves and increasingly start attempting to rein in these companies. So we saw a number of countries then start following the European quest for greater data privacy, emulating a variant of the GDPR type of regulations. We saw then exert more powers through antitrust laws, or start finding ways to impose limits on this freedom from liability when it comes to content moderation. So we really have seen this move away from the faith in tech companies' self-regulation, which is a direct backlash on this American market-driven model. And even the Americans themselves are now second-guessing and starting to think whether this techno-libertarian market-driven worldview is today suitable for governing the challenges of today's digital economy. So even then, Americans, if you look at various surveys, they want more privacy. And then what you also notice is that there are many bills proposed in Congress that would call for greater regulation of privacy, and then limitations to Section 230 that provide the liability when it comes to content moderation, or call for revival of antitrust laws. So we really have seen this overextended American digital empire now being attacked from within, but very much from abroad, which then causes some countries to move away from that, and that sees then the greater currency for the European and the Chinese regulatory models to gain traction.
Yeah, I find this really fascinating because I've long been arguing that regulation isn't necessarily an enemy to business and commerce and to what the companies want to do, but could in fact be its friend, and that the kind of over push on self-regulation around the turn of the century especially really wound up leading the US to essentially take a back seat and not be a leader on how to regulate these companies. And without a good answer from the US, I think the EU stepped in with an answer. And as a result, now, we are where we are, and there's this backlash, which maybe wouldn't have happened if companies were more receptive to having a good regulatory scheme in the U.S. already established, that would have not led to the kind of excesses that we have today. So it might be an interesting story that, in a sense, this overreach, as you describe it, is perhaps a kind of strategic failure on the part of the U.S. government and as well as industry, that ultimately has led to the fact that essentially EU is the main regulator of things at this point, and is really driving the conversation, introducing most of the concepts. There's a few concepts from the U.S. law, like the data breach notification, but the vast majority of the concepts are EU concepts, and they're, as you described here and in the book, they're also now taking over in the U.S. We're seeing laws that have the EU terms, data controller, data processor, The EU definition of personal data has taken over now in the new US laws. Sensitive data, a right to delete, all these from the EU are starting to work their way into US law. Things that I think, you go back 20 years would have been non-starters in US law, now are becoming staples of US privacy laws. So this is the sort of the I think deepening of what you call the Brussels effect. And I'm wondering what you think the future holds for this. Do you see this continuing? Do you see the EU continuing to be the leader in regulation? Are the efforts that are going on now in the US likely to make any difference?
Yeah, so in many ways, I see that the EU has an advantage here by having this political consensus on the need to regulate digital regulation. This is not a contested issue. The EU may have sometimes difficulties to enforce these regulations, but the political will is there. The regulatory architecture is there, generating rules after others towards more rights-driven regulatory model. So the GDPR was almost like the beginning of a set of different digital regulations that are now shaping the marketplace. Alongside the GDPR, there has been a set of antitrust actions challenging the monopolies, the monopolistic behavior of these companies. But also we saw very ambitious regulations to be adopted in the last couple of years. The Digital Services Act that deals with content moderation, and Digital Markets Act, that is an ex-ante antitrust type of regulation that is meant to limit the ability of digital gatekeepers to abuse their gatekeeper position. Then we are now seeing the EU being at the final stages of adopting an AI Act, which is going to be the world's first horizontal, comprehensive, binding regulation on AI. So in that sense, the machinery, the commitment, the political will is there, continuing to generate regulations. And I don't think that, even though we are seeing now a shift in conversations in the US, and we are seeing some states like California adopt privacy laws, we are seeing the massively sort of comprehensive executive order that the Biden administration adopted on artificial intelligence that tasks over 25 agencies to pursue many of the similar protections that are going to be embedded in the European AI Act. So we see a shift in the US. But I still think that the US has some peculiar challenges relating to how Congress operates, or how it fails to operate, that prevents the US from assuming this position as a global regulatory leader. So Congress still has not passed a federal privacy law, despite many attempts to introduce bills towards that effect. We have had many bills to revamp the antitrust laws. None of those significant ones have come to fruition. I think the revision of Section 230 and really take a different view on content moderation is very complicated because of the entrenched commitment to free speech and various constitutional First Amendment related challenges to overturn that consensus. So there seems to be growing bipartisan support to peel back some of these freedoms that have been granted to tech companies, yet an inability due to continuing polarization to really agree on the joint way of regulating. So in that sense, the Europeans are rather far ahead, and it might be a while before we see the US really offer an alternative. But the US is certainly now not sending the world a signal that what the EU is doing is reckless, because it is rather sending a signal that the US, even itself, is no longer trusting the market-driven model, and it is attempting to move closer towards the European rights-driven regulatory model.
Yeah, the U.S. is a complicated set of regulation and a complicated approach to emulate. I think one other reason that it's hard for the U.S. to sort of, compete with the GDPR, or before that, the directive, where a lot of laws around the world were patterned after. I mean, about more than 160 countries worldwide that have a comprehensive privacy law. The U.S. lacks one, but we do have quite a lot of laws, quite a number of federal sectoral laws, a growing number of state consumer privacy laws, about 13 or 14, depending on some, if you count them as such. There's the FTC Act, and the FTC is kind of what I call a quasi-common law style approach, which, if you look at what the FTC has interpreted to be violations of the FTC Act, are quite a number of things that are in the GDPR.
Yeah.
So yes, but the problem is it's a mess, and so it's very hard for another country to emulate that, because it's not as easy to cut and paste like you can do with the GDPR. And a couple things in terms of the spread of the GDPR that I think are really interesting. One is the fact that so many countries use that language and the same concepts. Some laws patterned after the directive, because the GDPR is essentially a lot of similar language and similar ideas as the directive. It's a successor to the directive. So over the last 25 years or so, so many countries around the world have created their comprehensive privacy laws on that model, including, interestingly, China. Their new law, the Personal Information Protection Law, PIPL, has a lot of things that look very similar to the GDPR, which is kind of ironic, given that the GDPR is a law passed with a human rights focus, and in China we have a authoritarian regime, a surveillance state, and yet they pass a similar law. And so I'm curious, when we see these cut and pastes of the GDPR or parts of the GDPR in these laws, are they really the same, or are they different? And so how is that, like how would you describe that kind of Brussels effect? Because it's sort of the language is there. Some of the concepts are there, but then there's a very different twist as we import this into these different countries. So I'm just curious, like what does that, what's your thought on what does that mean?
Yeah, so it's a very good question. So I think I would answer two levels. So one is that the European commitment to privacy and passing on an ambitious legislation like the GDPR sort of shifted the privacy conversation around the world. So it catalyzed the governments within their own jurisdictions, the various privacy advocacy groups within their own jurisdictions, to really elevate the political salience of data protection. And it also became on the radar of corporations who realized that, look, the ground underneath us is shifting. The expectations of consumers are shifting. There's now a public conversation where we recognize the harms to violations to data privacy. So that was already kind of the creating the momentum and shifting the expectations. Then there's a second very important effect, is that the EU's legislation was so comprehensive, and it started to become the kind of gold standard that the countries that then realized that there was a momentum, we needed to start regulating data privacy, who did they turn to? So there was no American data privacy regulation that they could have looked at. It seemed to be that the Europeans were so far ahead that became then the template. It was seen as being of the quality and the kind of global leader that the country started to emulate it. I mentioned also as a footnote, Dan, that there are some advantages that the EU has with its multiple languages. The GDPR also existed in French, in Portuguese, in Spanish. And it was very easy for countries in Francophone Africa or in Latin America to basically copy paste and plug it into their own legal systems, knowing also that any judicial decisions would exist in their own languages. Any additional guidance that the Commission would issue would also exist in their languages. So that also gives the Europeans an interesting advantage. But back to sort of why some countries adopted not entirely the GDPR, but partially, more strategically, including China. So some countries with significant regulatory capacity and somewhat different values, what we saw is that they took the GDPR template, but then they did some tweaks to make sure that it works with the political model of the country or with some other preferences that the country has that deviate from the preferences and values in Europe. So China indeed has many of the GDPR provisions embedded in the PIPL. But then it also explicitly contemplates for mass surveillance. So there is the degree of government's ability to, according to Europeans, much more invasive ways to infringe the individual's data privacy. There's also provisions on data localization that again is much more of a reflection of these state-driven commitments, more restrictive approach towards free flow of data. That comes naturally to the Chinese and that are part of their regulatory model. So they have combined these rights-driven GDPR provisions. And I think it's important for us to recognize we like to think about an important aspect of Chinese regulatory model, which is the focus on surveillance and censorship and oppression. But it's very hard for any government to govern simply by oppressing its people and restricting them. You also need to bring them some benefits, including then the Chinese have been quite concerned of consumer protection, of the company's ability to exploit consumers with various practices like price discrimination or commercial exploitation of their data. So even while the Chinese government preserves the government right in the name of social stability and political control to then engage in surveillance and compromise individuals' data privacy, there is some overlap when it comes to consumers' interest vis-a-vis companies, where we find similarities with the European Union.
So one component of the Brussels effect is the cross-border data transfer restrictions. Unlike the US really doesn't have anything like this, but the concept in the EU, going back to the directive from the mid-90s to the GDPR, is that in order for data about people in the EU to be transferred outside of the EU, the countries where the recipients are must have an adequate level of data protection, whatever that means. And that's actually been very contentious about what exactly the adequate level of data protection means. I think some interpretations will have a law or protections that are somewhat like the GDPR, although when you look at the adequacy decisions that have been issued, some of those laws are not that close, but at least have some things. And then there's also this other wrinkle that we see in the Schrems cases, where the issue of government access to the data and the surveillance by the government, and then the redress that people in the EU might be able to get to challenge that surveillance becomes a big issue.
Sure.
And this, from those, there have been two cases that Max Schrems has brought, both of which have invalidated ways that data can be transferred between the EU and the US. But I wonder just generally on the adequacy, does this drive countries to create laws in the EU model or close to it, because it is kind of dangling a wonderful carrot, or so delightful, it's like carrot cake, because it's, if you can get adequacy, that is such a boon to trade, to have the free transfer of data without all the impediments, because there are other ways to transfer the data, but they're cumbersome and clunky and time consuming and costly. Getting adequacy is great. So I wonder, does that help in a way spread the GDPR vis-a-vis the US, where you don't get anything like that?
Yeah, so absolutely. I think it is one of those that the seamless transfer of data is crucial for the number of industries and in a globalized economy. So if you look at how much of the data transfers actually contribute to the economic engagement across borders, it is really important for companies that they can do that within their own corporate structures, but also with counterparties within their industries and across. And this has been now a major concern indeed, that the Europeans feel that European data is not safe in the United States, which does not qualify for adequacy. As understood, like it doesn't provide an essentially equivalent level of protection for individuals' data privacy. And there's a particular concern of the extensive surveillance that the United States government is engaged in and known to practice. And the Europeans are particularly wary of what it then means to expose the European data, not just to the US tech companies, but then potentially also get that data transferred to the government. So this has led to this number of litigations, and right now we entered the phase where both the Europeans and Americans are now third time trying to come up with the kind of data transfer agreement, a privacy framework that would allow the data to transfer, and companies that sign on to this framework, that they could seamlessly transfer data. But it's still not, I don't think we've seen the last chapter in this. There are many privacy advocates who say that the US still does not meet the European criteria, and we still have deficiencies in the legal protections afforded to the Europeans. So we don't know whether even the more enhanced level of protections ultimately meet the exacting standard that was set by the European Court of Justice. But this is, I would say, just we now are, this is not just the transatlantic domain. There are many countries, as you say, that they are eager to receive the adequacy determination so that there would be a legal baseline and a presumption that we can operate our businesses across the border. So it is a huge incentive for these companies then to write their privacy laws so that they conform very closely to the GDPR's provisions, so that they have a high likelihood of qualifying for adequacy determination. So that is certainly, I completely agree with you. It is a major carrot, if you use that term, for these companies to align, for these countries to align their privacy practices with those that were drafted in Brussels.
Yeah, and I think even if you look at the litigation between in the Schrems cases, after each one, even though I think that the U.S. approach is still far off from the GDPR, it still gets nudged a little closer. The EU doesn't move closer to the U.S. The U.S. keeps moving closer to the EU each time. And I think over time, if you look at the direction that U.S. law has gone in, it has keeps migrating closer to the GDPR, but you really don't see the GDPR changing in any way, or EU law changing in any way to get closer to the US approach. So I think it's very interesting if we look at the direction that everybody's moving in. It definitely all seems to be, at different speeds, closing in on Brussels. And, it goes to your idea, the Brussels effect, that, it really is starting to take over. Even in the U.S., which has been reluctant, but still, with each iteration, with each litigation, with each different, from safe harbor to shield to now the privacy framework, it's getting just a little bit closer. So I think we'll see that. But then I wonder, that there's also now China and their vision. Tell me more about how they're starting to try to exert their influence, and perhaps counter the Brussels effect or address the Brussels effect. How are they competing in all this?
Yeah. So no, it's very interesting that I don't think there's a Beijing effect that would follow the same logic as the Brussels effect. One reason being that the Chinese market is not open to many of the tech companies, the Facebooks and the Googles, especially the ones that are in the process, in the business of being search engines. So basically information retrieval or operating a social media a platform. It is very hard to coexist and operate those businesses within the confines of the censorship in China. So we actually then don't have these global giants enter the Chinese market. They don't need to comply with Chinese regulations, which means they don't get globalized with the variant of the Beijing effect, variant of the Brussels effect. But that doesn't mean that China doesn't have any influence over global digital economy. So I mentioned how China is mainly exporting its power through infrastructure building. So Chinese companies are building these 5G networks and undersea cables and data centers. But also, very importantly, they are exporting surveillance technology. So this is very relevant for our conversation about privacy. that there are many countries around the world where the cities are acquiring Chinese surveillance technologies that are maintained by Chinese vendors that then allow them to, what China would say, more efficiently manage their cities, energy, traffic, what have you, and provide maybe safety features when you have law enforcement also use these cameras that allow them to find missing children or catch criminal activity and so forth. But especially the Americans and largely the Europeans too have expressed concern that this extensive network of surveillance architecture that is now spreading is also vesting governments with authoritarian surveillance capabilities. So these cameras can really be used to engage in mass surveillance of citizens in violation of their fundamental right to privacy. And the concern is that it may happen at two levels. So first of all, the domestic governments in places like Pakistan or Philippines or Ecuador that are buying a lot of Chinese infrastructure, or places in Africa like Zimbabwe, their own governments can then use these surveillance capabilities against dissidents domestically or otherwise then to compromise the right to privacy. But there's a second order concern that the US has often warned these countries against, is that your data through these surveillance technologies may also find its way to Beijing. And you are not only subject to surveillance by your own government, but surveillance by Beijing. And that is, I think, an important part of this conversation, and why we see the US, for instance, take a very hard line, not accepting the 5G infrastructure that is built by Huawei in the United States. But I think we also need to keep in mind that all these countries don't share the same concern over privacy. There are many developing countries that fundamentally desperately need the pathway to digital development. They need digital infrastructure, and China is providing one. That infrastructure is affordable and it is pretty good. And they say that, look, it's a luxury concern to worry about privacy. It's not the top 20 concerns that we have. So ultimately, it is the concern that the developed countries like the US and especially Europeans with a strong notion of privacy protection can afford to prioritize, whereas it's less salient for many of these countries that basically just need to prioritize what can we afford, who can provide that, and often the answer is China.
That's really interesting, especially given the U.S. At least used to have an interest in trying to promote democracy around the world, but perhaps that we're seeing it's in wane now, and even here in the United States. And so by not investing this way, are we going to lose this battle in the long run? One thing that was also really fascinating in the book is the amount of hypocrisy and inconsistency as we see the jostling of these three regimes, where there are a lot of things that they could do, but they stop short of. And why is that? What's going on to explain the fact that they are sometimes pulling their punches or fighting in some weird ways as they compete for global dominance?
Yeah. So I don't know which types of hypocrisy you refer to specifically, but one certainly is, if we stick to the domain of surveillance, is that there are those who critique and say that, look, US always focuses on surveillance by Beijing. But when the US government conducts surveillance, we call it national security. Whereas when Beijing conducts surveillance, it is basically surveillance or spying. So we need to acknowledge that all countries are engaged in surveillance. There are legitimate law enforcement, but also national security reasons that we do observe surveillance. And should we then single out surveillance by authoritarian country? Is that qualitatively different? And then there's a counter argument that says that, look, in countries like the United States, we still have independent courts and constitutional protections. There are more constraints in terms of how government conducts surveillance. And it's not just then pure hypocrisy to criticize the Chinese surveillance. So there's a concern, for instance, of the presence of TikTok in the US market, and even attempts to ban TikTok. And there are two concerns. So one is that the data that TikTok can collect of Americans using TikTok can be passed on to Beijing. That's one concern. Of course, Beijing and TikTok deny that. Second is that can be a tool for propaganda that basically then exposes Americans to messages that are drafted in Beijing. Again, something that the company and the Chinese government denies. But I think that is sort of one way to say that, is it then a hypocrisy to attack a Chinese company, even though the US companies have also been found to pass on data to national security agencies? So should the Europeans, for instance, be more concerned about TikTok or Facebook? And there, I think there is it depends a little bit who you ask that question, but there is a difference that I think there are few who are willing to say that a Chinese company is in a position to challenge the demands to hand over data. They don't drag the Chinese government to independent courts in China and resist those demands to hand over data. The US companies don't always do that. We know that sometimes they do comply with law enforcement authorities, but we also know of many prominent cases where, for instance, a company like Apple, in the case there was a big terrorist attack in San Bernardino in California, FBI wanted to have access to the phone of the terrorist and Apple to break the encryption, and Apple refused to do that and is willing to go to court basically to defend their own right to then protect the privacy of their equipment, their services, their products. So it is not necessarily clear that every time the US companies would be passing on that information to the same extent. So there are different constitutional court and other judicial protections that are present. But I think I can understand, and I think one can legitimately ask that, is it materially different who surveils you? And it was really interesting. I talked recently to one of the privacy architects of the European Commission who has been negotiating these privacy frameworks with the United States. And his view was that the Europeans don't want to be surveilled by the US government, by the Chinese government, nor by their own governments, that the commitment to fundamental privacy is so important and we need to protect it from any of these actors.
Yeah, and I think it's also interesting too. You describe a lot in the book how to develop the technologies and produce various components of those technologies that different parts of the world are interdependent on each other. So we can't China can't totally isolate itself, and the U.S. can't totally just cut off China and so on. We are interdependent, so that makes it hard to totally have the full on out battle that at the same time we push away, we also have to make exceptions. And I think that's a really fascinating discussion in your book about all that. When it comes to also, restricting markets and banning companies and so on. And also the companies have to play this very odd dance that you talk about, where they'll want to take certain stands about about rights and about freedoms, and they do, and then they also don't. Sometimes they end up cooperating in a lot of instances. But I wanted to actually spend a little time talking about AI, and we have the sort of new effort in this effort in the EU to regulate that. It looks like it might have hit a bit of a roadblock or speed bump very recently, but they're well underway. And what are your thoughts on this battle to come? How AI should be regulated, and how is that going to play out in this global stage?
Yeah. No, it's fascinating, Dan. So right now, I think the momentum and attention is really there on AI. Is this tremendously important revolution that will really offer just unprecedented benefits to societies, but also expose individuals and societies to potentially grave risks. So here, I think, and for those who care about privacy, it's also very critical, because AI offers just extremely powerful tools for mass surveillance. It is also a concern for those who worry about disinformation, because AI can really amplify our understanding of reality. It's a concern for those who worry about concentrated markets, because AI can further entrench the power of the leading tech companies that are now also the leaders in development of AI, and considering that you need tremendous resources to even be able to buy the computing power to run and develop these models. So the AI, I think, is an absolutely crucially and understandably now on the radar of all the governments. There too, the EU is really kind of ahead of the game. It started a couple of years ago in drafting this binding comprehensive AI Act. And there are many provisions where there is a political agreement. I would say that my understanding is, and we don't have full transparency on what's going on at these final stages of legislation, when we are trying to reconcile the position of the two co-legislators in the EU, the Parliament that represents the European citizens, and the Council that represents the member states. And here we have this dynamic that the Parliament has been more inclined to have a risk-averse approach and to impose greater obligations to the companies developing AI. They have been very strongly pro-privacy, very averse to exceptions for live biometric surveillance. So thinking about, for instance, real-time facial recognition technologies, whereas the Council has been more concerned also to say that, look, we also need to realize that we can't slow down innovation too much. We also need to think about law enforcement needs, national security needs, and also be able to then deploy this technology to meet those goals. So there is some disagreement still on this one. Another set of disagreement is that these foundation models, generative AI, including the ChatGPT, that came pretty late in the process, where the laws were almost ready to be sort of released and to be agreed upon. And right now, then, the Europeans face this need to also incorporate the foundation models within the legal frameworks. And that's where, when you were referring to those speed bumps and sort of the challenges in these final stages of legislation, that's what we are experiencing right now. But to put this a little bit in the broader context, and when we talk about three empires and three regulatory models, this is exactly what we are seeing. So the US has traditionally been very focused on innovation in AI, more willing to extract just voluntary commitments from these tech companies. The EU went ahead and started drafting its rights-driven regulatory model that is imposing binding obligations, so really grounding those obligations into rule of law and subjecting them to democratic oversight. China is also pursuing binding regulations, but doing it a little bit more in an iterative way, like one by one. First, recommendation algorithms, then deep synthesis technology, now generative AI. The next step is to negotiate also a more general AI law. But there, the Chinese do have some similar concerns with the Europeans, but also China does, because of political reasons, worry about a couple of issues that are contrary to how Europeans view AI. So AI can be a powerful tool for political surveillance if you think about facial recognition technology, where China is the leader in supply and demand. But then also, Chinese government needs to ensure that generative AI remains consistent with the censorship regime. And these generative AI, the ChatGPTs of the world, the Chinese variants of those, will not produce information that would then destabilize the information environment and contradict the socialist values of the state. So there too, that this framing around three analytical frameworks seems to be holding up. And we see this additional tendency of the US moving away now slowly from the market-driven model towards the European rights-driven model with the executive order, yet still falling short, not having a bipartisan legislation that would be as comprehensive or anything like that likely to be adopted anytime soon.
So one argument that I often hear made when it comes to regulating AI is that if we regulate AI with too heavy a hand, without a light touch, essentially that would give an advantage to companies and countries that are not regulating with that light touch. So I often hear, well, if we regulate too hard on privacy and other things with AI and restrict innovation, then that's going to give the Chinese, who are not subject to that regulation, a leg up. What are your reactions to this argument? Because you're critical of arguments like this in the book.
Yeah, so Dan, I think that really captures the way that I try to explain that in the book analytically. We should think about these regulatory battles taking place at two levels. We have a horizontal battle between the empires. So we have the US-China tech war. We have these US-EU regulatory battles like over data transfers that we have discussed. But then we have these vertical battles where at the same time, each empire is fighting the tech companies within their own jurisdictions. But these two levels of battles intersect. So the US now is considering that it would need to ramp up the vertical battle and actually rein in its tech companies. But that conversation, whether to regulate AI, whether to regulate privacy, takes place in the shadow of that horizontal battle. And that leaves the US concerned that they cannot constrain their tech companies too much, else they are curtailing the very asset they have in the horizontal battle against China. The US cannot afford to lose the AI war because it is about economic power, geopolitical power, technological power, military power, ideological power. This is something where the US needs to make sure that its main asset, the leading tech companies that are leading in AI development, continue to be able to innovate. So that introduces some restraint into these battles. But at the same time, I'm less sympathetic to this idea that the US tech companies should be able to deploy this argument. So the reason we see restraint is that they have successfully deployed this argument. But right now, the momentum is to regulate. China is regulating AI, the Europeans are regulating AI, and I think the US needs to ask the very hard question, is that the kind of digital society that is consistent with the values of the US, is that really the kind of society where we are prepared to expose individuals and societies to the kind of risks that unmitigated AI development would expose those citizens and that society to do? And thereby, I think it doesn't necessarily need to be that regulation of AI, if the regulation is done right, is constraining of innovation. There's so much that explains why America leads in AI revolution that has very little to do with issues like, yes, there's no federal privacy law. That is not the secret of America. The secret is that there is a robust, integrated market where the companies can scale. There's fantastically efficient capital markets where US tech companies, including AI developers, can fund their innovations. There are legal frameworks that encourage risk-taking, that allow the entrepreneurs to fail and get a second chance. And very importantly, the US has been able to recruit the world's best talent. That China is drawing on its very talented, vast population. The US is drawing on the entire world. And it still is the place where the world's leading innovators want to come and innovate. Again, if there is a set of regulation that limits how we can feed these models with data of individuals that would compromise their privacy rights, so do we actually need to ask for their consent? Or do we need to make sure that there are security reviews, some kind of licensing, or some other ways that we need to carry out safety tests and hand over those safety tests to the government to show that our models are safe? That doesn't mean that that would be the end of innovation in the United States. In many ways, that just generates more trusts in these technologies, which can increase the uptake of these technologies in the marketplace.
Yeah, a related argument that you critique in the book that I hear constantly is that because so few of the largest tech companies come from the EU, and some say, well, that's because of all the strict regulation in the EU, because of the GDPR, because of the directive, because of all the privacy protections that has stifled the ability of tech companies to thrive in the EU. And you critique this and offer a number of reasons, some of which you've already discussed. And I'm curious if you have further thoughts on that argument that the existing regulation out there has really stifled innovation, or what's your response to that?
Yeah, so then I take a strong view in the book that I concede that the Europeans have issues with innovation. The Europeans are behind both the US and China in the actual tech race. But I don't think it is because Europeans care about fundamental right to privacy and have adopted a GDPR. If the Europeans tomorrow repeal the GDPR or tomorrow decided that, okay, let's forget the AI Act and go back to the tracks and decide that let's go all out and encourage development. It is not that suddenly a year from now or 5 years from now, this massive hubs of European AI unicorns would emerge from Europe. Because exactly those features that I was mentioning that make American innovators so robust, even if there are some regulatory constraints, many of those are missing in Europe. So one of the big issues that the Europeans ought to be focusing on so they can maintain the GDPRs and other regulations, but they need to make sure they also finish the digital single market. It's still very fragmented, and it is hard for European tech companies to scale in the EU if they meet 27 different regulatory frameworks. So there's a long way to go to make sure that you can smoothly operate across this vast common market. Second is really that there is no capital markets union that has been completed. So we need much deeper integrated pool of capital that can fund European innovations. So currently, European companies do really well in the first few funding rounds, but then when they need more capital, they basically acquired by American tech giants, or they need to turn to US venture capital. So that's one. Then I mentioned already this risk taking. So culturally, Europeans are more averse to risk. And you do need to be comfortable with risk taking and comfortable with failure if you really want to pursue disruptive innovations that really matter. There's also bankruptcy laws. If you look at some OECD studies and look at how punitive bankruptcy laws are, the most punitive bankruptcy laws are in markets like Sweden and Czech Republic and Portugal. And least punitive, the ones that really allow for entrepreneurs to have a second chance, which then gives them the permission to innovate and try hard things, are in places like Canada and the United States. So that's one thing. And then what I was mentioning is immigration. So Europeans need a proactive plan to attract the global talent to the EU. That's much more significant than then trying to somehow compromise on its commitment to protect fundamental rights. So I think that's where the Europeans also have a long way to go to make sure that the global talent would find Europe to be the place where they want to be and where they want to innovate.
Yeah, I find it really interesting too that in the U.S., so many of these companies start in California, which is the most, they have high taxes. It's not the most, you think the most business friendly state to see this emerge in, and and also the most privacy regulation of any state. So, and yet they're there, and I think one reason is, I think that's where the party is. I mean, that's where everybody else is. That's where everybody is, and they're together. And I think there's something to the fact that, everybody knows to come here to the US, to certain places where everybody's at, where all the talent's at.
Yeah.
And, if we promote that, that's like the biggest generator, in spite of all the regulation and everything else, that really is that, everybody who is working on these things, are in the same location and can readily move about to different companies. And that I think is tremendously valuable, and is driving the fact that, it's no surprise that, everything's coming, so much is coming out of Silicon Valley.
Yeah.
So I want to thank you so much for a really fascinating conversation and for writing a glorious book. It's a tour de force. I urge everybody to read this book. There is so much really interesting information here. And we focused a lot on the privacy aspects of your book, but you also talk about antitrust, and you talk about other regulation, export controls, and just a fascinating background to what is happening in the world. A lot on privacy in the book, but it puts it in a context of all these issues and how they interrelate. So I really urge everybody to read more. We scratched the surface of the book here. There's a lot more in here, that is, it's great. So thank you so much. And it's been a real thrill to chat with you today.
Thanks so much for having me, Dan. Really enjoyed the questions and the conversation. So thanks, everyone.
Thank you.